There are moments in a courtroom that no one forgets. Not the verdicts, not the dramatic final arguments. The moments that stay with people, the ones that get whispered about in hallways, repeated at dinner tables, and passed down by clerks and bailiffs for years, are the ones where someone with power decides they are simply above the room. I've spent a long time studying how authority works, how it's built, how it's maintained, and how, in one unguarded moment, it can be completely dismantled. And what I'm about to tell you is one of the clearest examples I have ever come across of a person who confused his title with his worth. This is the story of a district attorney named Garrett Whitmore, a man who, by the time this story ends, had no career left to speak of, and the judge who made sure of it. Pay attention to how this unfolds, because it didn't happen all at once. It happened in layers, and every single layer tells you something important about what happens when arrogance meets the wrong room. Garrett Whitmore had been a district attorney for 11 years by the time any of this came to a head. He was known throughout the county, not universally loved, but widely feared, which in certain legal circles amounts to nearly the same thing. He had a conviction rate that looked impressive on paper, a staff that worked in quiet terror of his moods, and a reputation for closing cases in ways that made defense attorneys uncomfortable and reporters eager. He was the kind of man who filled a room not because of warmth, but because of the particular energy that comes from someone who believes, truly and completely, that the room exists for them. He drove a car that cost more than most of his prosecutors earned in a year. He kept a bottle of aged scotch in his office that he never offered to share. His suits were tailored, his shoes were shined, and when he walked into a courthouse, he expected people to move. Most of the time they did. That's the thing about power that's never really been challenged. It starts to feel like gravity, natural, inevitable, like it was always meant to be this way. Whitmore had appeared before many judges in his career. He had disagreements, of course, legal arguments, procedural disputes, sentencing debates. But there was always an undertow of deference in how those moments resolved. Judges knew him. His office had weight, and he was very good at making it clear, without ever quite saying so, that crossing him had a cost. Until he walked into Courtroom 14 on a Tuesday morning in October and appeared before the Honorable Elaine Marsh. Judge Elaine Marsh had been on the bench for 19 years. She was 61 years old, had handled over 4,000 cases, and was known, without fanfare or self-promotion, as one of the most careful jurists in the state. Her courtroom ran on time. Her rulings were precise. Her demeanor was so steady that new attorneys sometimes mistook her composure for indifference, right up until the moment they realized she had caught something they missed, something important, and she had simply been waiting for the right moment to address it. She did not move when people expected her to move. She did not raise her voice. She had never needed to. That morning, Whitmore arrived 7 minutes late to a pre-trial hearing. Not by accident. His assistant had actually called ahead to say he would be delayed. His paralegal had brought the files. There was no apology. He walked in, nodded at the room in the way that people nod at furniture, and seated himself at the prosecution table. Judge Marsh noted the time. She said nothing yet. The hearing began. It involved a case that, on the surface, appeared routine, an arraignment matter with some evidentiary questions attached. The defendant was a man named Terrence Okafor, 34 years old, a warehouse manager accused of a financial crime that his attorney, a quiet but meticulous woman named Sandra Cole, was already building arguments to challenge. Sandra Cole had been practicing law for 8 years. She was careful, she was organized, and she was deeply aware that her client, a man with a clean record, a steady job, and 2 young daughters, was facing a charge that, if not challenged properly, could end the life he had spent years building. She had motions prepared. She had case law. She was ready. Whitmore's office, as it turned out, had not submitted their response documents on time. Not by a day. By 4 days. And they had not flagged this, not apologized for it, not asked for an extension. They had simply arrived and expected to proceed. Judge Marsh looked at her clerk. Her clerk confirmed the filing timeline. She looked at Whitmore. "Mr. Whitmore," she said, "the prosecution's response was due last Friday. We are now on Tuesday. Can you explain the delay?" Whitmore looked up from his papers. He looked at her the way a person looks at a minor inconvenience, a traffic cone in a parking lot, something to be acknowledged and moved past. "Judge, my office has been managing a significant docket. This hearing was rescheduled twice. I think we can proceed without getting bogged down in procedure." The room went very still. Sandra Cole kept her face neutral. She had been in enough courtrooms to know what she had just heard, and she knew better than to react visibly. But she noted it. Everyone in that room noted it. Because what Whitmore had just done, casually, almost bored, was not simply ignore a procedural deadline. He had suggested, openly, that the judge's enforcement of that deadline was the problem. That running a proper courtroom was getting bogged down. That his convenience was more relevant than the rules that governed everyone else in the room. Judge Marsh said nothing for a moment. She looked at the filing dates again. She looked at Whitmore. Her expression did not change. "Mr. Whitmore," she said, "in this courtroom, procedural rules exist for a reason. The defense has a right to timely responses. Your office's docket management is not this court's concern. We are going to address the late filing before we proceed." Whitmore exhaled, not loudly, but audibly, the kind of exhale a person makes when they feel they are being forced to explain something obvious to someone who should already understand. "Your Honor, I've been practicing law in this county for 22 years. I think I understand procedural requirements." "Then you understand why I'm raising them," Judge Marsh replied. There was a pause. And then Whitmore did something that several people present would later describe in very specific, almost identical terms. He smiled, not warmly, the smile of someone who is deciding in real time that the person they are dealing with is simply not at their level. "Of course," he said, in a tone that communicated the opposite. The hearing continued, and with it, so did the slow accumulation of moments. Whitmore interrupted Sandra Cole twice while she was speaking. Not sharply, not with urgency, with the casual interruption of someone who does not consider the other person's words important enough to wait for. Both times, Judge Marsh stopped him. Both times, he nodded as though absorbing a point he already knew and said, "Of course, Your Honor," in that same tone, the tone that said he was playing along. At one point, the discussion turned to a piece of evidence that Cole was challenging on the grounds that it had been obtained through a search that may have exceeded the scope of the warrant. It was a serious legal question. Cole had prepared a detailed argument. She began to walk through it methodically, citing relevant case law, speaking clearly and precisely. Whitmore turned to his paralegal and said something, quietly, but not quietly enough. Several people heard it. The words were something like, "We'll be here all day." Judge Marsh stopped the proceedings. "Mr. Whitmore," her voice was even. It was always even. "Is there something you'd like to share with the court?" "No, Your Honor." "Then I'd ask you to give counsel your full attention while she presents her argument. That's not a suggestion." Whitmore looked at the judge. She looked back. His jaw tightened, almost imperceptibly. "Understood," he said. Sandra Cole continued, and to her credit, she did not rush. She laid out her argument as carefully as she had prepared it. She was thorough. She was good. When she finished, Judge Marsh asked Whitmore for the prosecution's response. He gave one, competent, rehearsed, the kind of argument that wins on technical grounds when the other side is unprepared. But Cole had been prepared, and Judge Marsh asked follow-up questions, probing ones, the kind that require actual engagement with the legal substance rather than the procedural muscle that Whitmore's office usually relied on. He stumbled slightly, not catastrophically, but enough. The hearing broke for a brief recess, and this is where things changed. During recesses, the formal rules of decorum relax somewhat. People stand, stretch, speak to their clients, check messages. It is understood as a pause, not an ending. The judge had not yet left the bench area. She was reviewing something with her clerk at the side of the bench, a few feet away, engaged in a quiet technical discussion about scheduling. Whitmore approached the prosecution table, picked up his phone, and made a call. The courtroom was not empty. There were clerks, a bailiff, Sandra Cole speaking with her client, and several other individuals present. The room had sound, and Whitmore, either not caring or not noticing, spoke at a volume that carried. The call, as best as could be reconstructed afterward, was to someone in his office, and the content of the call was not about the case. It was about the judge. He said, in words that would later be cited in formal proceedings, that Judge Marsh was playing games, that she was out of her depth on the evidentiary side, and that he intended to make a few calls after the hearing to address the situation. He used her name. He used her courtroom number. He spoke with the confidence of someone who had made similar calls before and had seen them produce results. The bailiff heard it. 3 clerks heard it. Sandra Cole heard it. Her client heard it. And Judge Marsh, still at the side of the bench, heard it too. She did not turn around immediately. She finished her conversation with her clerk. She set down her papers. She returned to her seat. And then she called the room back to order. What followed was methodical, not dramatic, methodical, which is, in many ways, more devastating than drama. Judge Marsh looked at Whitmore. She spoke at the same steady volume she always used. Mr. Whitmore, before we resume, I want to address something. During the recess, I was present in this room. So were several court personnel. I want to give you an opportunity to clarify something I believe was said within earshot of this court. Whitmore looked up, and for the first time since he had walked in that morning, something shifted behind his eyes. A flicker. The first recognition that the ground might not be as solid as it had seemed. I'm not sure what you're referring to, he said, carefully now. I believe you are, Judge Marsh said, but I'll be specific. I heard comments made during the recess, on a phone call, regarding this court, regarding my handling of this hearing, and regarding intentions to contact parties outside this proceeding to, and I'm going to use the words I believe I heard, address the situation. I want you to be very precise with your next answer. The room was completely silent. No shuffling, no coughing. The kind of silence that only forms when every person in a space understands that something important is happening. Whitmore said nothing for several seconds. Then he said, Your Honor, I think there may have been a miscommunication. That's not a clarification, Judge Marsh said. That's a deflection. He stopped. She continued. Mr. Whitmore, in 22 years of practice, you have presumably appeared before many judges. And I imagine that in those 22 years, a pattern developed, a pattern in which the weight of your office, your relationships, and your reputation were enough to resolve most friction in your favor. I am telling you, clearly and without ambiguity, that this courtroom does not operate that way. And I am further telling you that what I believe I overheard today, if it is what I believe it to be, constitutes an attempt to improperly influence the conduct of these proceedings. That is not a procedural matter. That is a conduct matter, and I intend to treat it as one. She did not throw him out of the courtroom. She did not hold him in contempt on the spot. Both of those things would have been dramatic. She did not do dramatic. What she did was finish the hearing, properly, thoroughly, with every procedural step in place. She ruled on the evidentiary challenge. She ruled in favor of the defense on 2 of the 3 points, meaning that significant portions of the prosecution's case against Terrence Okafor were now in question. Then she asked all parties except Whitmore to step out briefly while she addressed a matter with him directly. What happened in the next 12 minutes, by accounts from those who were just outside the door, involved no raised voices. There was no argument audible. It was quiet. The quiet of someone who has no more need for volume. When the door opened, Whitmore walked out. His posture was different, not broken, but different. The easy confidence was gone. He looked like a man who had just understood, for the first time, that something he had always assumed was guaranteed was not. Judge Marsh filed a formal complaint that afternoon. It went to the state's Judicial Conduct Board, not as an allegation requiring investigation, but as a documented account of events observed directly by the judge, witnessed by named court personnel, and supported by the presence of multiple individuals who had also heard what was said. The complaint was specific. It cited the late filing and dismissive response to it. It cited the interruptions. It cited the comment made to the paralegal during opposing counsel's argument. And most critically, it cited the phone call, the words used, the intent expressed. Whitmore's office issued a statement 2 days later, calling the complaint a misunderstanding and an overreach. His colleagues publicly offered support. Privately, several of them said nothing, the silence of people who had watched the situation develop over years and had learned to say very little. The investigation took several months. Whitmore retained a private attorney, which, to many who knew him, was itself a signal. Men who are fully certain of their position do not retain attorneys. They state their case. They let their record speak. He retained an attorney on the third day. The investigation surfaced things that the phone call had only hinted at. It turned out that the comments about making calls were not idle posturing. There was a documented history, not of overt misconduct in each instance, but of a pattern. Cases where judges who ruled against Whitmore's office found themselves involved in administrative complications shortly afterward. A judicial appointment process in which Whitmore's name appeared in communications in ways that raised questions. 2 prosecutors in his office who, when interviewed privately, described a culture in which pressure was used as a management tool and deference was expected, not earned. None of it was the kind of thing that lands with a single headline. It was the kind of thing that builds, line by line, document by document, statement by statement. Sandra Cole's case moved forward without the compromised evidence. The charge against Terrence Okafor was ultimately reduced significantly. He did not go to prison. He went home to his daughters. He later said in an interview with a local reporter that he had sat in that courtroom on that Tuesday morning genuinely terrified. That he had watched the DA arrive late and behave the way he did and had felt something drop in his chest. The feeling of understanding that the system might not have room for him. That watching Judge Marsh respond the way she did had changed something for him. Not just about the case, about whether the room had space for someone like him in it. He said it quietly. He said it once. He didn't need to say more. Whitmore resigned his position 8 months after the hearing. The formal statement cited personal reasons and a desire to pursue opportunities in private practice. It was brief. It was careful. It had clearly been drafted by someone whose job was to find the most damage-controlled version of the truth. Private practice, as it turned out, did not go smoothly. The complaint and investigation were public record. The pattern that had been documented was public record. And the specific details of what had happened in Courtroom 14 on that Tuesday morning had circulated in the way that courtroom stories always circulate, through clerks and bailiffs and attorneys and paralegals, carried in conversation, in emails, in quiet moments over coffee. His name carried a different weight now, not the weight of fear, the weight of a cautionary story, the weight of someone people mentioned when they needed an example of how not to walk into a room. There is something worth sitting with here, because this story is not simply about one man losing a career. Those stories are common enough. People in power lose positions all the time, through scandal, through negligence, through the slow erosion of political favor. This was different. What Garrett Whitmore lost was not just his title. He lost the operating assumption that had structured his entire professional life. The assumption that the room would bend to him, that his history, his relationships, his reputation, his carefully cultivated network of implicit understandings would always be enough to resolve the friction in his favor. That assumption had been accurate for a long time. That's what made it so dangerous. Power that is never resisted stops being something that needs to justify itself. It becomes, in the mind of the person holding it, simply how things are. Judge Marsh didn't break Whitmore by being louder or more powerful. She broke his operating assumption by simply refusing to confirm it, by holding the line on a late filing, by not letting an exhaled breath pass without acknowledgement, by staying in the room during the recess, by not pretending that the phone call hadn't happened. She didn't reach for him. She didn't need to. She simply did not move. And in not moving, she made clear that the room had its own gravity, and that gravity did not belong to him. There is a particular kind of person who enters positions of authority and confuses the respect the position commands with the respect that they personally deserve. They are not always cruel. They are not always obviously corrupt. Often they are capable, even skilled. But somewhere along the way, the lines between the office and the person dissolve. The title becomes the identity. The deference becomes the expectation. And when that happens, when a person can no longer distinguish between the authority they were given and the authority they have earned, they become genuinely dangerous. Not always in obvious ways, sometimes in quiet ways, in the cases that don't get heard, in the evidence that disappears before reaching a defense attorney, in the witnesses who are never quite interviewed properly, in the people, like Terrence Okafor, who sit in courtrooms terrified, wondering if there is space for them in the system they were taught to trust. The most important thing Judge Marsh did that October morning wasn't technical. It wasn't procedural, though the procedural steps mattered. The most important thing she did was make the room honest again. She reminded everyone present, Whitmore, his paralegal, Sandra Cole, Terrence Okafor, the clerks, the bailiff, that the courtroom is not a place that exists to confirm power. It is a place that exists to interrogate it. That's what courts are for, at their best. Not to affirm the comfortable, to make the powerful answer. Elaine Marsh did not give interviews about the case. She did not become a public figure. She returned to her courtroom and continued doing what she had always done, holding hearings on time, asking the questions that needed to be asked, and expecting that the rules of the room would be respected by everyone in it, regardless of their title or their track record or how many calls they thought they could make. She did not need the story. She already knew what had happened. The story belongs to the rest of us, as a reminder that authority is only as honest as the people willing to hold it accountable. That arrogance doesn't always announce itself loudly. Sometimes it arrives 7 minutes late, exhales at inconvenient questions, and makes phone calls during recesses, fully expecting that the room will forget what it heard. And sometimes, in the best possible version of things, the room doesn't forget. Sometimes the room has a judge in it who was paying attention the whole time, and that makes all the difference.